Good afternoon. Can I start by issuing a small health warning? I know that in lockdown, a lot of us have got kids wandering in and out, half listening to these webinars, which we are broadcasting in our houses. If that is the case for you, I would just say that some of the subject matter that I'm going to be touching on may be better suited to listening to it behind closed doors. So I shall leave that with you. What is Section 41 of the Youth Justice and Criminal Evidence Act? It governs the questioning of complainants in sexual offence allegations about their sexual history. And I say history, which suggests sexual behaviour prior to the indicted incident. Well, in fact, of course, it means any sexual behaviour other than that which is the subject of the indictment. So not just pre-allegation, but post-allegation sexual behaviour. The section's been around for a long time now, but since it came into effect, it hasn't always been applied consistently by trial judges. And every time a controversial decision is made, there's media and policy debate about whether it goes far enough or whether it should be further tightened up. And the most recent public example of this is the Ched Evans case, which I'll come on to in a little while. And this is the subject of the title of this webinar. Let me start by giving a roundup of the history of asking such questions in court in serious sexual offence allegations. Up until the mid-70s, this used to be an area governed exclusively by the common law, arguably a bit of a Wild West situation where previous sexual history questions would and could be asked in order to discredit complainants on moral grounds. And of course, in the 70s, as in the 60s, the world was a rapidly changing place in terms of women's rights, women's emancipation in general, and of course that had a knock-on effect on public perception of what was normal sexual behaviour for women. And so in 1976, the Sexual Offences Amendment Act was created in an attempt to curtail the wildly differing application of the common law by judges across the land. A report had been compiled the year before called the Heilbronn Report. That report recommended that such previous sexual behaviour should only be admitted if it was strikingly similar to what was in the indictment. And strikingly similar is a trigger phrase that practitioners recognise, of course, from the history and development of the similar fact doctrine. In the final analysis in the 1976 Act, that quite high proposed threshold was watered down, and the test to be applied in Section 2 of that Act was simply no evidence and no question in cross-examination shall be adduced or asked by or on behalf of any defendant about any sexual experience of a complainant with a person other than the defendant without leave of the judge. So the judge could override the restriction if it would be unfair to the defendant not to allow the questions to be asked. Fairly broad discretion given to the trial judge. Significantly, Section 2 restricted questioning on sexual experience with everyone but the defendant himself. Questions about sexual experience with the defendant were still on the table. More on that in a moment. The legislative format created by the 1976 Act carried on for 2 decades until the creation of the Youth Justice and Criminal Evidence Act in 1999. By 1999, there was dissatisfaction with the state of affairs surrounding this type of questioning, and there was some legislative appetite for tightening those provisions up. Culturally, again, the world was a very different place. Very significant and material changes had taken place in how women and their sexual behaviour and habits were perceived. Enter 41 of the 1999 Act, a nightmarish labyrinth of hurdles and dead ends. Can you please, yes, thank you, Andrew. I see you've put up the nightmare on the screen. Now, this is a plea for mercy. I have deliberately sacrificed attractive presentation in order to fit all that I need on one page, so that I don't have to trouble Andrew asking to go back and forth more than I need to. So apologies if glasses are needed to have a good look at it. There's a lot to say about section 41, and I wouldn't hope to cover it all today in any event. So what I have done here is I have only copied the text of the sections I will be referring to the most today. So I have summarised the content of some of the other parts of the section. All emphasis is my emphasis, and anything in square brackets is something I have deliberately paraphrased to keep it brief. So looking at the slide, section 41, no questions about any sexual behaviour. The court may not give leave unless it is satisfied. So we start with the hurdles now. Subsection 3 or 5 applies, and even if you get through the gateways in either subsection 3 or 5, it has to be the case that a refusal of leave might have the result of rendering unsafe a conclusion of the jury on any relevant issue. Subsection 3, which is the most controversial and complicated subsection. This subsection applies if the evidence or question relates to a relevant issue and either the issue is not an issue of consent. Well, one example of an issue which is not an issue of consent is the question of reasonable belief in consent. The two are very much overlapping concepts in ordinary parlance, but the reasonable belief in consent is not an issue relating to consent. So either that issue is not an issue of consent, or it is an issue of consent and the sexual behaviour of the complainant to which the evidence or question relates is alleged to have taken place at or about the same time as the indictment. Or the relevant sexual behaviour of the complainant is alleged to have been so similar to any sexual behaviour of the complainant which was part of the indictment, or any other sexual behaviour of the complainant which took place at or about the same time as the indictment, so similar that the similarity cannot be reasonably explained as coincidence. So that is where most of the controversy comes up. It is that subsection 3, although I can't leave out subsection 4, which of course covers the, effectively, that is the rape myths catch-all. Subsection 4, no question to be allowed if the main purpose is to impugn the credibility of a witness, which is a hangover from the unchaste woman and the general myths about that. Of course, subsection 5 is important as well, but I'm not going to cover it today. Leave can be given to adduce that sort of material in order to rebut or explain prosecution evidence. In addition to that, just at the bottom there, any evidence which is sought to be adduced of previous sexual behaviour has to relate to specific instances of sexual behaviour. That is not you were a prostitute at the time, or you were inclined to have casual sex at the time with whoever came along. It has to be specific instances. So if I can just quickly have the third slide, please, Andrew. Or is it the second slide? That's the one. Definitions. Section 42 defines certain things. Relevant issue in the case, any issue falling to be proved by prosecution or defence. Issue of consent is the issue of consent in fact, and specifically excludes reasonable belief in consent. C, sexual behaviour, what is it? Well, the courts have given a fairly wide umbrella to cover fairly wide range of behaviours which are classed sexual behaviour, to protect complainants from sort of roving inquiries. Having an abortion, not sexual behaviour. Lying about sexual allegations is not sexual behaviour. Sexy photos can be sexual behaviour. in a case of a 13-year-old who was alleging being trafficked. She referred to a boyfriend who had tried to abduct her, and the judge ruled that out, amongst other things. The judge ruled that out because that gave the impression of an intimate relationship, and she was only 13, and to say that something was a boyfriend would imply some kind of sexual behaviour. So at the outer limits of sexual behaviour is really quite generous. If you can go back to the first slide, Andrew, if you wouldn't mind, thank you. We have that just open while I go through. So in the blizzard of conjunctive clauses that you can see there, two things jump out when you examine section 41. The first is that all sexual behaviour history is now restricted. That is not just with third parties, but with the defendant himself, and that is a material change from the 1976 Act. The second thing that jumps out is that there is no general discretionary judicial safety valve built into the section. Now, both of those aspects caused consternation at the time. Relationship evidence between the complainant and the defendant, which under the previous regime would very likely go in, was now on the face of it not admissible unless it could fit through one of the narrow gateways in section 3 or section 5. And there was no way, it was argued, for judges to ensure fair trials in situations which did not fit through any gateway, but which nevertheless common sense dictated were relevant and probative of an issue such as consent or honest mistaken belief in consent as it was under the 1956 Act. One such case where this came up was Crown and A, which is a House of Lords case. I'm not going to ask Andrew to go there, but at the end of this presentation, there's one slide which has all citations for the cases I'm mentioning. The brief facts of that allegation were the complainant and the defendant's friend were in a sexual relationship. On a particular day in June of 2000, she and the defendant's friend had sex at the flat that the two men shared. The defendant wasn't there at that time. Later on, the defendant came back to the flat and the three of them went for a picnic. All three were drinking. Later that night, on return to the flat, the friend collapsed and needed to go to hospital by ambulance. The complainant and the defendant remained in the flat. They then decided to walk to the hospital together along a canal towpath. Defendant fell down. He pulled the complainant down to the floor where she says he raped her. So the defendant said in his prepared statement that the sex was consensual. He also said that the two of them had had sex before in the preceding month, and the last of these occasions had been approximately a week before the night of the indictment. He wanted to be able to put the fact of that relationship before the jury in order to bolster his assertion of consent. Of course, that was under the old regime before the 2003 Sexual Offences Act was passed. So it was honest mistaken belief was his consent, and honest mistaken belief in consent was his defence. So the defence wanted to adduce the prior sexual history with him, as well as the fact of her having had sex with a friend earlier on that day. And a ruling was made by the judge at a preparatory hearing that yes, the sex with the friend earlier in the evening could go in under section 41(3)(b at or about the same time. But no, the relationship between the defendant and the complainant could not go in under subsection 3b or 3c. There was no temporal or similarity link to get it through any gateway. So the effect of that would have been the arguably nonsensical position that the jury would hear about the sex with the friend earlier on, query what purpose that would realistically in fact serve, but not the previous consenting sex between the defendant and the complainant. Clearly, if the complainant had had consenting sex with him on a previous occasion, that didn't mean that she had consented on this occasion. But by way of simple relevance, the difference between the jury being left with the notion of the complainant having sex with his defendant for the first time in the circumstances of that night versus having sex with him, having done so before, the difference is dramatic, arguably. But that is what the statute appeared to prevent. Well, the sympathetic judge gave leave to appeal his ruling. Court of Appeal, all parties agreed that, in fact, although it could have gone in under another heading, the previous sexual history between the complainant and the other man had wrongly been ruled admissible. It wasn't relevant. However, the judge had been right to rule that the evidence relating to the complainant and the defendant's sexual history did not fit through the Section 3C gateway. In fact, although it would have been admissible through another gateway, they were inclined to certify a question for the House of Lords for the obvious reason that there was a real risk that the defendant might not have a fair trial if the statute prevented potentially relevant and probative evidence from being adduced at trial. The certified question for the House of Lords was, may a sexual relationship between a defendant and complainant be relevant to the issue of consent so as to render its exclusion under Section 41 a contravention of the defendant's right to a fair trial? Well, cut a long story short, the answer to this question was yes. The provision, if strictly construed, could constitute a contravention of the right to a fair trial under the ECHR. The Lords' solution to this, by way of avoiding a declaration of incompatibility, was to read down the wording of the section, effectively reinstating in one fell swoop a considerable amount of the judicial discretion which Parliament had apparently removed with the 1999 Act. To quote Lord Steyne, the test of admissibility is whether the evidence is nevertheless so relevant to the issue of consent that to exclude it would endanger the fairness of the trial under Article 6. If this test is satisfied, the evidence should not be excluded. Well, there it is. That was received with consternation by crisis groups, but mostly with relief by practitioners and by judges who had been despairing at their inability to admit such evidence when it was manifestly clear, in a minority of cases, that justice and fairness required that it should be admitted. It's worth noting that their lordships were happy that Section 41 did provide an appropriate and proportionate restraint on the questioning of complainants about sexual behaviour with third parties, on the basis that it was likely to be much harder to justify on the grounds of relevance. So, with noble observations in mind, how do we get to the situation in the Ched Evans case, which was exactly that, evidence about non-contemporaneous sex with third parties, and not just one, but two. Reported cases where evidence of sex with third parties has been properly admitted and found to be so by the appeal courts are pretty on the ground. Some of the parameters are to be found in the following couple of cases. I won't ask Andrew to change the slide, but it will come up at the end. You can pause it if necessary. Case of White in 2004. The complainant had been a street-based prostitute, but she now traded from her flat with only a few trusted clients. She alleged a rape by an acquaintance, the defendant. He said that she was consenting, and when he woke up, they had a row as she was going through his wallet. And it was sought to put in that she was currently still a prostitute. And this fell foul of both 41.3 on relevance and the provision in Section 41.6 down the bottom of the slide, which makes it clear there have to be specific instances of sexual behaviour, not just generalised instances. Again, the Court of Appeal said this, referring back to the House of Lords case of A. In our judgment, Crown and A is not authority for any wider reading of Section 41 by force of Section 3 of the Human Rights Act. In a case where sexual acts of the complainant with men other than the appellant are sought to be adduced, then is justified by the application of a conventional canons of construction. At the least, it would take a very special case to accommodate evidence of such acts in circumstances in which they would not be accommodated by an ordinary reading of the section. As far as third parties are concerned, the appeal court seem to be adhering to the general rule that you should let in, where relevant, relationship evidence, but you shouldn't let in evidence of sex with third parties. Case of T in 2004. This was a case, this is a similarity case. This was a case where the previous sexual history between the defendant and the complainant. So it's not a third party case, but it gives a little illustration of the similarities required to pass the similarity test. The allegation was that the complainant had been raped by her long-term partner inside a climbing frame in a children's play area in 2 different sexual positions. And the Court of Appeal held that evidence of the complainant previously having had consenting sex with the defendant in that same child's climbing frame some weeks before the indicted offence met the test of similarity such as to justify its admissibility through Gateway 3C1. A few years later, another case of interest called Hamadi in 2007. Again, this is a strange case, but all of these cases, the ones that reach the Court of Appeal, the ones that get reported, tend to have slightly odd facts. On her account, the complainant had a row with her boyfriend and was walking home in the middle of the night. She accepted a lift from the defendant. He drove her to a patch of wasteland and they smoked a joint together. She relieved herself. When she got back in the truck, he kissed her. She briefly responded, but then refused to go any further. He then raped her, she said, attempting to use, for part of the time, some cable ties to attach her hands to the door handles. His defence was that she instigated the kissing and the sex, and moreover, it was she who wanted to use the cable ties, and she was annoyed with him for not being keen on that particular role play. He said that she then used a torch to masturbate herself afterwards. So the 2 accounts couldn't have been more diametrically opposed on one view. The defendant sought to introduce evidence that she had been unfaithful to her boyfriend by having sex with other people during the course of the relationship. The 3 criteria most cited when this case is quoted elsewhere are the open air, the being having sex with people other than her boyfriend, and the fact that it was winter time. The application was in fact partly made in an attempt to rebut a comment she made in cross-examination about not wanting to have sex with a stranger, but partly because it was argued that there were similarities with the indicted incident, which was again open air, person other than her boyfriend, and winter time. So the judge refused leave, refused the appeal on those grounds. The judge, the first instance judge refused leave to admit the evidence on those grounds, and the Court of Appeal agreed, because even if it were true that she had done those things and she was inclined to have sex with people other than her boyfriend, it didn't have any direct bearing on the issue of consent with this defendant on that night. So that similar behaviour wasn't, to quote the section, so similar that it couldn't be reasonably explained as a coincidence within the meaning of subsection 3C. What is of interest in that case, and which is not often mentioned in commentary, is that is what the trial judge did allow in that case. He did the judge did allow in a third-party sexual encounter where the complainant had asked someone to tie her up with cable ties. The judge also allowed in evidence from 2 other witnesses from the bar earlier that evening of the complainant jumping into people's arms and simulating sex. So that case is an interesting illustration of a picture of a judge who is picking her way through this particular minefield. In the time given, I won't go through too many. I'm not too much to go now, but it is clear that the hurdles in asking questions or seeking to get any kind of evidence in under section 41 are considerably higher than the hurdles to be overcome in an application to adduce bad character under section 100. On to Ched Evans. Has that case changed things significantly in terms of cases since then? The short answer is not that much, actually. You will recall this case. Welsh footballer, accused of rape, tried in 2012, convicted. Appeal was dismissed the first time, and then it was reviewed back. It was referred. It was reviewed by the Criminal Cases Review Commission, referred back to the Court of Appeal on the question of fresh evidence. The conviction was quashed, and he was subsequently retried and acquitted later on. The facts can be summarised as follows. Evans's friend met up with the complainant after a night out, both drunk, go back to a hotel room which had been booked in Evans's name. In the cab on the way back to the hotel, McDonald, the friend, texted Evans to say words to the effect of, "I've got a bird," something like that. The complainant wakes up the next day and has no memory of what has happened. She's not alleging that she has been raped. It is others who raise the alarm subsequently. Evans is arrested and he gives the following account. He made his way to the hotel. When he got there, the complainant was having sex with his friend. Evans gave her oral sex and then had sex with her at her request. She then changed position, went on all fours and encouraged him verbally with words like "go harder," "F me harder" and similar. They did it in that position. Both the men left afterwards, and the Crown put the case on the basis that the complainant was too drunk to consent. Evans was convicted on that basis. Subsequent to his conviction, 2 witnesses were found who were able, it seemed, to give evidence of having had sex with the complainant, one a few weeks before and the other a couple of weeks after the indicted incident. Similarities were put forward. The similarities were said to be the complainant had enthusiastically encouraged them to have sex, adopted the doggy position and uttered the same encouragement to F me harder or go harder or whatever it was, that sort of tone. All of this, of course, when she was drunk, had drunk a fair amount. The witness who had had sex with her subsequently said that in respect of some occasions he had been with her, she hadn't remembered the following day whether they had had sex or not. So again, that was put forward as a very relevant consideration. Putting aside for a moment the flaws in the way that these 2 witnesses were found, located, and the appeal for witnesses, the flouting of the rules on anonymity of complainants on social media and so on, and the fact that the intimate details of the trial had already been on the internet by the time the witnesses came forward. The Court of Appeal nevertheless had to tussle with what they had to say. What was it relevant to? Was it relevant? And could it be admissible? The prosecution argued, amongst other things, that the type of behaviour described was ordinary and commonplace. The commencement of sex in one position, the subsequent adoption of another position, the utterance of verbal encouragement. These things were not outside the realms of coincidence, such as to bring them within the meaning of subsection 3C1. The defence submitted that the behaviour and the words were not ordinary, and in fact they had a cumulative effect when enough people said them effectively, when taken together, which meant that they couldn't reasonably be discounted or explained as a coincidence, and that taken together with the loss of memory the next day was compelling evidence. And it was relevant to the question of actual consent, because it couldn't arguably be relevant to the question of his reasonable belief in consent, because Evans didn't know either of those other 2 men, and he certainly didn't know about that on that night. Although again, this is a topic which I'm not going to go into, but has been the subject of much discussion, whether it could be relevant to reasonable belief in consent as well. The Court of Appeal found that yes, this fresh evidence was relevant to the question of whether she consented or not. They used the widening of the discretionary gateway achieved in the House of Lords in the case of A. Was that a significant watering down of the similarity criterion? Were those characteristics unusual or rare enough to justify? Well, you may recall there was something of a public outcry afterwards from crisis groups again. Harriet Harman tabled a private members bill which sought to tighten up once again, the legislation. There was a lot of outcry. A lot of the outcry, the overlapping outcry, was to do with the appalling treatment of the complainant on social media. And in the final analysis, the change of legislation didn't in fact happen. And subsequent surveys of advocates have found that the Section 41 is not, in practice, being routinely watered down or ridden roughshod over. So arguably, in the final analysis, the case of Ched Evans is not actually kicked open any floodgates, any significant floodgates, because it turned so much on its own facts, not least because of the way the witnesses came to light, the deployment of private investigators and the unlikelihood in normal cases of that kind of evidence actually being found. The proof of the pudding is in the eating. Subsequent Court of Appeal cases have not shown great deference to that decision, even in cases which concern prior sexual history with the defendant himself are comparatively thin on the ground. And two of those which post-date the case of Evans, which don't reference it at all, are Guthrie and Smith, which can be found on the final slide, which you will find in a moment when Andrew flips to it. So I hope that again is a very short tour of Section 41, something to do on a windy Thursday during lockdown. Thank you very much for listening. Over to you, Andrew.